Welcome to Module 4, Lecture 1 of Social Media Law and Risk Management. This week we're looking at intellectual property laws and a few corporate laws that might involve social media. Your main reading for this week is Chapter 8 of your text, Copycats and Corporate Capers. Today we're having a quick look at your learning problem because it's mainly associated with next week's topic, but there is an element of copyright in this one. We'll be looking at Web 2 and intellectual property and how that works. We'll home in on copyright briefly, looking at some basic global principles and some international differences. We'll look at the basic defences to copyright, which centre around free use, and fair dealing. We'll consider copyright and social media and special implications there, and we'll look at some other intellectual property and corporate laws that impact on social media use in the corporate environment. We'll then pose a few discussion questions, as we always do. Well, the learning problem this week is mainly to do with discriminatory, race hate types of material, which we look at next week. And you'll notice that the topic is centred on a political situation with a high Muslim population, and it's where they're trying to attract the Muslim vote through fairly radical social media means and some fairly extreme actions which could trigger some discrimination, some hate laws, and perhaps even some anti-terror laws attached. However, there is one aspect that should be the backdrop to this week's talk. It says, I also have a terrific passage from a best-selling novel that is anti-Islam, and I'll cut and paste that and do it up so it looks like a newspaper column under her name. Upload it using BitTorrent and get a bunch of people to share it on social media. Meanwhile, I'll ask Sheldon to set up a fake Twitter account under the name Muhammad Akbar with a scary bearded headshot to start making physical threats against her. So you can see part of the problem involves cutting and pasting, appropriating some material that someone else has written in a different work. And we'll look at where that might factor into the equation as we look at today's material. As usual, the learning problem does ask all of those basic questions that you're getting quite familiar with now as we move well into the course. So I won't waste time in today's lecture by talking through those, but of course it culminates in your consideration of both stakeholder theory and how that might apply, which underpins the course, and then it works through into how you might build remedial measures or preventative measures into any social media policy that you draft. Both of those are important to your assignments. Well, intellectual property in this Web 2 context, and we certainly live in a cut and paste generation now where everybody is appropriating material and either portraying it as their own or not asking for permission to use that. The trouble is that in a corporate context, me in a university context, perhaps you in a local government or a corporate organisation, we can't afford to do that. People might do it privately, but intellectual property laws come into play, particularly if we're representing an organisation, because we leave that organisation liable for major breach of intellectual property suits. There are some lessons there in the chapter with the Rachel Kane case. Now, Rachel Kane was the blogger in America who chose to satirise the fashions that were being promoted by the fashion house Forever 21. And the textbook explains that she got very serious legal threats from Forever 21 over her satirising of their fashions. Well, Rachel Kane was just a poor individual blogger, but she stuck to her guns and engaged lawyers and took them on to the extent that The lawyers, it seemed, managed to scare away Forever 21's lawyers. Perhaps Forever 21 didn't want the publicity associated with this David and Goliath legal action, so they then left her alone, and she continues that blog. To my knowledge, she continues it today. So there's a good story, I guess, coming out of it, but I'm fairly sure that if you represented a large corporation, perhaps a media outlet trying to do that same act, it may not have gone away because it wouldn't have been as much of a David and Goliath kind of action. Intellectual property is often defined as creations of the mind, and like real property, there is a whole area of law attached to defending your right to your own creations. There are many kinds of intellectual property that we can produce, and the main kinds the main kinds of intellectual property law are copyright, moral rights, patents, and trademarks. And it really is a double-edged sword, because with intellectual property, on the one hand, 1 hour of the day at work, you might be wanting to appropriate someone else's material in some way. Perhaps grab an image off the internet and whack it into your promotional brochure. So, in other words, borrow, or some might say steal, someone else's work. On the other hand, you might have created something yourself. Perhaps it's the words that surround that very image that you hold dear to your heart. You've created them. They're particularly well crafted, and somebody else might at some stage try to steal or plagiarise those words of yours. So you can either be the plaintiff or the defendant in an intellectual property case. The basic principles, and these are enshrined in global agreements, international agreements, which started back in the 1880s. And also, not only the World Intellectual Property Organisation agreements that were created, but also various free trade agreements over the years. Signed agreements between different countries have established fairly standard copyright and intellectual property protocols. A very basic and important principle is copyright will not protect an idea alone. So you might have some idea for some great movie story that you would like to pitch to a producer, and you tell your friend about this idea at the coffee shop. Nothing's written down, there's not a treatment developed in any way, and the next thing you know, your friend has written the script based around that idea, pitched it to a producer, and suddenly the film is going to be produced and become a bestseller. Well, you don't have a leg to stand on as far as copyright goes, because your idea is not actionable. You can't defend. There's no copyright that rests in that idea. Your friend, though, once they've written the script, has given a form of expression to that idea, and that's what gets protected with copyright. Now, the form of expression can take all sorts of different forms. Clearly, words, just as in that script, which would be classed as a literary work. There's also artistic works, images, paintings, drawings, and we've got books, articles, photographs, even in some places, computer software or programs can be protected this way. There are, though, important international differences. Now, some of these differences have been negotiated through the various free trade agreements that I mentioned earlier. So some countries have different rules. One of the rules concerns whether you need to use that copyright symbol on work to have it protected. Some countries require the registration and the use of such a symbol, whereas countries like Australia do not. So that's something you will need to look closely at. The duration of copyright is also something that varies under international law. And in most parts of the world, copyright lasts until 50 years after the death of the creator. That won't concern most of us as the creator, but it could concern us if we want to use the work of someone who died more than 50 years ago. In other countries, though, that it's 70 years after their death that they or their, not they of course, but their estates would still hold the copyright to their work. So, and that applies in Australia and in the United States, a 70-year period. So you need to go a bit further back in history to be able to cut and paste that piece of literary work. Copyright also rests in translations. I learned this recently when I collaborated with some colleagues on a book about mindful journalism, drawing upon Buddhist translations. Yes, the works themselves were sometimes more than 1,000 years old, but they'd been translated quite recently, and the translator was still alive, and so the translation itself becomes a work that is protected by copyright, and we had to write to various Buddhist monks to get their permission to use their translations in our book. What varies also, as I've already mentioned, is whether or not you register your copyright with a government agency. And that's certainly the case in the United States. Certainly to take action for a breach of copyright, your work first needs to have been registered in the United States with a Copyright Office. The biggest problem of all, I guess, with copyright is the enforcement of copyright law varies markedly between different jurisdictions. As we all know, as we've visited some countries where there are clearly bootlegged items for sale on the streets, and perhaps copies of books that have been cheaply printed that would be under copyright elsewhere, DVDs, CDs, T-shirts, fashion items. Some countries just do not enforce their international agreements with copyright. The defences to copyright do vary a little across different countries according to their wording and strength. And one of those defences is the key defence if you are appropriating a fair proportion of someone's work. Say you're just taking a few paragraphs of their book and you're using it for certain purposes, perhaps for the reporting of news, perhaps for commentary, maybe for an educational purpose, perhaps even for satire. Well, countries vary on the extent to which this is protected and what they actually call it. In some places it's called fair use, and in other cases it's called fair dealing. There's also the phenomenon of free use, where we have organisations like Creative Commons, which allow people to use, where authors and creators agree to allow people to use work freely, large whole sections of work, sometimes whole works, as long as it's attributed appropriately. The safest approach, if you're in any doubt about any of these things, is to get the creators' permission to use their work. And even if if they themselves do have the power to assign or license that permission, and that might require some payment for its use, particularly with larger organisations, media groups that put a price on the work that's been created under their budgets. The US expression, which is used in some parts of the world, of fair use as a defence, is broader than Australia's fair dealing defence. And that's been the subject of some debate and proposals for reform in Australia in recent years. It may well be reformed fairly soon, depending on the government that's in power. With social media, there's huge debates over the extent to which copyright applies on Web 2 and social media. There's certainly some debate over whether what you say in a 140-character tweet might be subject to copyright. One argument is that a particular artistic form of expression, a unique form of expression might be developed. Say, for example, a haiku poem could be written in the form of a tweet, which some would argue would constitute a protectable work. On the other hand, the counter-argument is that tweets are just so short that there's not enough substance to copyright, and further, that someone that does send such a tweet, if they are the creator, they can't argue that you've breached their copyright if you retweet it, because that's the very nature of the medium. The problem might become, though, if someone tries to tweet their own cutting and pasting of someone else's haiku poem, and we haven't yet seen cases which explore this. So there's a misconception in some social media platforms that people give up their copyright when they post it to social media. The law does tend to favour that view because that is the nature of the terms of service agreements of most of the social media platforms, which we learn in a later class. But nevertheless, it can be contested because such terms of service are so complex and wordy that who would ever be expected to read them? Again, we're short of cases in this area, but don't just assume that because someone has put it on social media that they are granting you copyright in the material or license to use it. But also, the thing you can't be sure of is whether it's actually their work that they've posted. While someone might whack a video up onto YouTube and say you can use it, it doesn't mean they haven't downloaded it themselves from somewhere else or appropriated someone else's work. So it's very important to verify whether it is actually theirs to post or link in the first place. There's debate over whether linking itself is a breach of copyright. It seems that the law is developing in the area that it is not to link to something unless you knowingly breach the copyright through the link, through the wording of your link itself. But the jury is still out in this area. It's been some Canadian decisions that have decided that there might not be breach of copyright, and in some cases there might not be defamation in a link by simply linking to material itself. But we've yet to see courts in most jurisdictions decide on this. There are other important intellectual property laws and corporate laws stated in your textbook, and these link with social media. The one that links to your learning problem is to do with moral rights. And moral rights are, even if you've sold your copyright to someone else, you do have the right to be the work to be attributed to you and not to have your work handled unfairly. Look at that aspect of moral rights when you're doing your learning problem. There's also the big issue of personality rights in the celebrity area, and America has much more developed personality rights than we do. This is where you're appropriating people's images and things and using them in the wrong context. Beware of the area covered in the text on cyber squatting, where people take your domain names and sometimes your social media accounts. We talk a little bit about trademarks and patents. I'd say the main message there is not to start using big corporate names in the wrong context. Stick to the more generic name. Rather than calling it a Band-Aid, you might call it a first aid bandage, that kind of thing. We talk about unfair dismissal laws and social media policies. And this is a big area which we need to start looking at more closely as we move into social media policies. And the laws related to trade practices, particularly where you might post something to social media which is misleading or deceptive to consumers. In other words, making some false representation or claim to consumers. And the final two big areas are professional liability, the extent to which you could be sued over professional liability through your work, say as a public relations practitioner, and negligence, because it could be through your behaviour that you have been negligent in your social media actions and your clients sue you for your negligence by for getting them into trouble. Our discussion questions are ones that I want you to go onto the discussion board to talk about. So please get in there and start engaging with those discussion questions, because they will inform both your learning journal in the area and your development of your social media policies for your final assignment. So today we've looked at this crucial field of intellectual property. Your chapter gives more detail, and we've focused particularly on the area of copyright. We've looked at moral rights as well, which affect your learning problem. And we've just foreshadowed just some of the corporate laws that impact on social media. We need to think about these areas and their impact on our learning problem before we look at next week's material, which also has much higher relevance to your learning problem as we look at discrimination and race hate laws or hate speech. So jump onto those discussion boards, start workshopping those questions and your learning problem, and we'll see you next week for discrimination and hate speech.